Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have three arguments this morning. The first one is number 24 CF 191, Marquette Jordan versus United States. Mr. Clark, whenever you are ready.
Thank you. Good morning, Your Honors. May it please the court. Jason Clark on behalf of Marquette Jordan, and I would like to reserve 4 minutes for a rebuttal if I could. The Sixth Amendment requires a unanimous verdict. Thus, courts have held that a deliberating juror cannot be removed unless the record leaves, a deliberating juror cannot be removed if the record leaves any reasonable doubt that the removal stems from their view of the merits. The possibility is more than reasonable here on this record. The record strongly suggests, if not commands, the outcome or acknowledgement that Juror 15 appeared to be a holdout. Rather than address the constitutional issue that the court faced, the court did not seem to recognize it. And what it did was it abused its discretion. It engaged in an end run around the required analysis that this court imposed under Shadakar. The court could not simply declare Juror 15 to be unavailable. That was not supported in the record, and the law does not support that type of end run.
Mr. Clark, I find this a really difficult case. So let me ask you this. In part, what happened in this case is that the trial court heard from Juror 15 before the discussion about his not participating and the like, that he had financial problems and he wanted off the jury. He did construction drawings for people. He couldn't get his work done. He couldn't make any money. He was behind on his mortgage. And everybody said, oh, wait, we thought this was the juror who was retired. He never mentioned any of this during voir dire. What's this about? And as you know, the court called in the juror, asked him about this. And at the end of the conversation, the court basically said, this is all a ruse. This guy just wants off the jury. That was the court's impression. And then when the discussion came after the notes from the other jurors about his not participating, the court once again said, see, I was right. That's exactly what's going on here. Now talk to juror number 15, and his answer to the question, are you having trouble deliberating because you can't pass judgment, is just no. And I mean, the court's clear impression was he gave that answer because that seemed like the answer that was going to get him off the jury. She didn't believe him. So when we get to the analysis of what his removal stemmed from, this weighs heavily to me. And I wonder if you could address that, because I think, I mean, if the question or if the standard is set out in Shadakari were simply, is there a reasonable possibility that this juror was a holdout? I think it's probably right to say, yes, there is a reasonable possibility. But the standard is there a reasonable possibility that the removal stemmed from his being a holdout? And that causes us, I think, to look in two places, at what the court was thinking and what the other complaining jurors were thinking about. And so I wonder if you could address what I've described when you say reasonable possibility, because I think it's the stemmed from you have to pay attention to, and you have to pay attention to it in light of all that preceded it, which I'm sure you understand better than I do what did. So what's your response to that?
My response is that I think you have accurately described what Juror 15 had done the day before, which was, it was a ruse. And the reason for that ruse, which I think is apparent in the record, is that there was disagreement, and that at that point, he did want off of the jury. But he wanted off of the jury, at least it's reasonably possible, because of the long-running disagreement, because he'd been stuck in this trial for a month. They'd been deliberating for 5 days when he sends that original note, and then 6th day when he actually is removed from the jury. but it's the length of time before he actually says that. He's been serving on this jury for a month, and now the day before he's actually removed, he says, oh, actually, I've been missing work for a month and I couldn't possibly do it for any longer period of time. And then we also have what happens in the following day, where the trial judge specifically asks him, does this have anything to do with what we talked to you yesterday about? Are you having financial difficulties? Is that the problem? And he says no. And I think that that does go to the fact, or at least the reasonableness of the possibility that it was a ruse. The day before was him trying to get off of the jury because he no longer felt comfortable, because he was being pressured, as defense counsel, outlined in their arguments against his removal, that was all part of what was, yes, stemming or causing it. I also
please continue your answer if you're still on Judge Thompson's question.
I think that in whether or not his removal stems from his view of the evidence is not just an analysis of sort of why or the court's ultimate reason for removing him, but the reason that he comes to the court's attention in the first place, the reason that the government asks for his removal. I think that all of those things go into whether or not it stems from it. So it's not purely the court's own reasoning, but just why the issue came up in the first place.
I was just going to ask about the right way to think about the test in your view. So let's say at the outset of deliberations, juror 15 goes back there and day one says, look, guys, I've made up my mind. Here's what I think. It's guilty or innocent. I'm not interested in hearing what anybody else has to say. That's my conclusion. You guys can come around to it, great. Or if you don't, we're just going to be deadlocked. But so far as I'm concerned, I've said my piece. Can that juror be removed?
That's a very difficult question.
I know that.
It is very close to the facts of Israel, which I know, Judge Thompson, you were the author of that case. I think distinguishing that scenario from Israel is the fact that in Israel, the juror went back and immediately said, look, I think the implication was, I don't want to go back to work. So whatever you guys are saying, I'm not going to agree with it. And we're going to be here a week later because, I don't like my job and I don't want to participate. And then you have the additional issue in Israel where the juror physically leaves the juror room so that deliberations cannot take place. I think in your scenario, it is a very difficult case, but I would say that it would not be appropriate on those facts alone, as long as the juror stays in the room and listens to what the other jurors are saying. If they have, and the thing is,
can I just pause you there? Because there is some evidence here that the juror is not listening to what other jurors are saying. So I guess my question is, do you think there's a threshold? I mean, what do we do with that? What do we do with a juror who says, yes, I have made a decision? Do they need to deliberate for a day and then it's fair game to shut down? Do they have to deliberate for an hour and then it's fair game? At what point can the failure to deliberate based on pure obstinance, I'm just not that interested in what these other people have to say, disqualifies somebody in a way that permits their removal? Because, I mean, it is part of the juror's obligation. They're instructed and go back there, keep an open mind, listen. Is it a matter of how long they do it for? I mean, I think we're on the 6th day of deliberations when juror 15 is removed. So is that, how much does that matter?
It does matter, because it does suggest that the reason for the removal is not the failure to deliberate. So it does help in this case that it's not until the actual 6th day of deliberation that it really comes to a head, the issue here. In your scenario where he goes back and he immediately has taken a position, and I think that the answer is, if his reason for taking that position has to do with the merits of the case, then he cannot be removed. And if the reason that if he is giving a reason in the case, and there's actually there's a good opinion out of the Ninth Circuit, Litwin, where it addresses exactly this issue. How much can we actually expect of a juror? And I think that there is, I know, a quote in my brief, and I'm forgetting the name of the case, but all we can really expect of a juror who is deliberating is to initially go back there with an open mind and listen to some of their jurors, some of the arguments, at least initially. But if that doesn't change their mind, and if that doesn't change their actual view of the merits, then if a dismissal stems from that, then I would say that that is inappropriate under the Sixth Amendment, and that.
So my question for
violates-
you, counsel, is how we ferret some of that out? Because that seems like a particularly fraught area for us. I mean, we at least got complaints from one other juror that, well, he's not sitting there deliberating with us. He's kind of playing on his cell phone. And at the trial court level, the ask was, oh, they should have asked the Gallagher questions. And it seems like that creates a serious danger of a mistrial if the judge starts delving too much into the merits of the discussion, as opposed to figuring out how we just deliberate. How would you propose to prevent that if we're trying to craft a standard here?
Well, I think that is why the standard that we have is so high, is because really we don't want the trial court delving into these issues unless what appears on its face appears to be some sort of actual, malfeasance from the get-go. And I think that the position that the Second Circuit and the initial position from the DC Circuit out of Brown was the fact that actually, yeah, we want to avoid going into these issues. We want to avoid questioning the jury. Jury secrecy trumps over the need to investigate jury misconduct. And so unless the misconduct is clearly external, or there is something clearly outside of it, we're not going to delve into it. And that's the point of having the standard so high, is that just don't go into it unless it is clearly external, because the secrecy of the jury is paramount to the need to uncover possible misconduct. At this point, unless the misconduct is clearly outside of their view of the evidence, don't go into it, because it is too dangerous, and the need for jury secrecy trumps those other concerns.
So can I ask, how does your standard comport with Shotakari itself, where I appreciate there is a threat of violence in Shotakari, but there's more than a reasonable possibility, and almost it's fairly clear that that violence stemmed from a disagreement about the merits. The two jurors who were at each other's throats because they disagreed. That's what animated. And I ask this because your brief sort of makes it like a but-for cause. If sort of the thing that is bubbling under the surface that gives rise to this removal is a view about the merits, then you can't strike them. And that can't be right, I don't think, because I think Shotakari is a counterexample. So how does your view comport with Shotakari?
I actually think that Shotakari, I think that in that opinion, the court twice said that the disagreement did not stem from the merits. When questioned, the juror said this had nothing to do with the merits. The physical, the fight that broke out when the court questioned the jurors about him, is that it didn't have to do with the case. It seemed like the juror had felt some sort of personal insult, as I recall. But I do think that one of the important factors in that was that there was an indication, at least, that the fight had nothing to do with the merits of the case.
Really? You think that matters? You think if we had a juror who was back there and said, you know what, you disagree with me one more time, and I'm going to smash your face in. That seems to me unquestionably has to be good cause for removal. You've created an atmosphere of fear among the jurors. They can't possibly deliberate, or it's at least, I mean, I know you might say, well, maybe it's just a grounds for a mistrial. It's definitely that, but it also seems, and I had thought, maybe I'm misremembering the facts of Shotakari. I had thought there's at least a reasonable possibility, whatever they said about it, that it was stemming from their disagreement. But so on my hypothetical, say one more thing in favor of guilt, and I'm going to smash your face in, that juror can't be removed?
I would say that if what precipitates the fight, the insults or whatever, if it is their disagreement about the evidence, I think that puts the trial court in a difficult position of declaring a mistrial. And I think that that is what is required, because we have to allow the Sixth Amendment to unanimity to prevail over these other concerns. And that's why it's so important, is that it is the constitutional right.
I wonder if you think the following has any bearing on our analysis here. I was really interested in the timeline here. And so on the day before the trial court had the discussion with juror 15 about his financial situation, the jury sends a note and they ask, do we have to be unanimous in acquitting the defendant of second-degree murder in order to move to the manslaughter charge? And the court answers that question, yes, you do. And so what I want to ask you about is sort of the way that question was posed to me. Perhaps you disagree with this. To me, the question, do we have to be unanimous in acquitting of second-degree murder, sounds like there were a lot of people that wanted to acquit of second-degree murder, but somebody was holding out as to that, or a few people were holding out as to that. My question to you is, should that affect our assessment of whether juror 15 was likely a holdout for, I'll say, non-conviction? I was going to say acquittal, but for non-conviction. Do you understand my question?
I understand the question. And I think that what is more clear is what comes from juror 13 and their note, where they're specifically saying that we have one juror who is not willing to make a judgment against others. And I think that that really tells us what juror 15's position was, that he was for the acquittal. I did not read much into the earlier note, other than to say that it again was an issue about unanimity, which suggested that there were still disagreements, that they were still wrestling with that issue. But when we get juror 13's note, we know that one person is now holding out in favor of the defense, because they won't make a judgment, at least as far as, as juror 13 is judging what their other juror is thinking.
Yeah, I mean, you're right that the juror's language was judgment against, not just a judgment, right?
Yes, but in this context, I think the judgment against has to be a judgment against Mr. Jordan. The other issue is purely the timing. And I think that your opinion in Israel made a big deal about how what Judge Weisberg had done in that case may not have been appropriate if it had occurred on the 5th day of deliberations. But as in that case, it was the juror had immediately, even before the deliberations discussions started, declared their intent to derail everything, that gave an indication. But as we are 5 days in, the timing suggests the issue is the disagreement. And what we have is in Israel, after they replaced the juror, there was 3 more days of deliberations. So you had noted that in your opinion as well. But here, after the 6 days of deliberation, they replaced the juror. They bring in a replacement juror for the following day, and I believe it's within a day and a half, they have a verdict. And this trial's been going for a month. They've been deliberating for 6 days, and then they replace the one juror and they get a resolution in a day. And I think that timing speaks to the fact that juror 15 clearly was a holdout.
Remind me of when this trial started. What was the date?
Now, November 14th, and the juror is dismissed December 14th. And if there are any other questions, I'm happy to rest on my brief as far as the other issues.
Yeah, I know we've taken you over your time, but we'll give you a few minutes in rebuttal.
Thank you.
We will hear from Ms. Gabriel for the government.
Good morning. May it please the court, Elizabeth Gabriel on behalf of the United States. The trial court did not abuse its discretion in dismissing juror 15 after finding that he was unwilling or unable to perform his duties as a juror. The court here conducted a thorough inquiry and had a firm factual basis for its decision. And I do want to set the legal framework here because I think it's important and it has to guide this court's decision. The question is not whether there was a reasonable possibility that juror 15 was a holdout. It's not whether he was a dissenting juror. The question is whether there's a reasonable possibility that the impetus for his dismissal stemmed from his views. And the record makes very clear that the court here was concerned with his ability to sit and deliberate with his fellow jurors, to exchange ideas with them, to listen to them, and to engage in the process. I think it's notable that defense counsel doesn't once mention the notes sent by juror 28 and juror 13 and the voir dire of juror 28, because those statements are telling here. Each of those jurors highlighted juror 15's misunderstanding of the process, inability to or unwillingness to participate in the process. Juror 28's voir dire made clear that juror 15 just didn't engage at all. He wouldn't share any ideas, even when asked to share any thoughts. He would not participate.
Can you explain that a little bit? He wouldn't share thoughts throughout the previous 5 days, or he was no longer engaged?
Well, juror 28 says that he was quiet from the beginning. At first, she wasn't sure, she just noted that he was quiet. But then in the last couple of days, I guess his lack of participation kind of became more apparent and came to a head. And in those days, he was playing on his phone. He was not listening to his fellow jurors. I mean, this kind of behavior is very similar to what took place in Israel, where the juror was not engaging, was ignoring, putting her head down, closing her eyes.
In Israel, that was, as we described it, that was right off the bat. That was before the recalcitrance in Israel was before the deliberations had even begun. And the record we have here is a juror who says, yes, I've been actively engaging. We're now on day 6, and nobody says otherwise. She only talks to one other juror. She only talks to juror 28, unlike just about every other case where they seem to bring in all the jurors and ask them. So we don't have anything to suggest he didn't deliberate for 4 days. Maybe, juror 28 at least says a couple days. So maybe we'll add another day to him not participating to her liking. So that's a pretty striking difference. Is there a point at which, let's say this were going on for 10 days, what would your view be if a juror said, Judge, yeah, I'm done listening. I'm done listening because I've made up my mind. Everybody said everything there is to say. Nobody's going to convince me otherwise. Do you think you can remove that juror?
I think if the juror has actually sat and listened and engaged and taken part in the deliberative process, if the juror has reached a conclusion that on the evidence and wants to adhere to that, no, I think, if that's the basis for the removal is that this is a holdout and he's simply an impediment to the jury, then I think, no, the juror could not be removed. But again, what is the impetus? That's the critical question.
When you look at impetus, who are we looking at? The judge or the complaining jurors? So do we look at sort of what motivated jurors at 28? Is that the number? Is that the right number?
Right.
28 and 13 were the 2 jurors who wrote notes. Do we look at what motivated them? And the reason I ask is this. I think you're right to say that they described non-participation. This juror is not participating. He's playing with his phone. But as has been mentioned a few times, this note comes 6 days into trial. And, one might say, well, if that's what he had been doing all along, the court would have probably heard about this a little sooner. Day 2, maybe there should have been a note saying, hey, wait, this juror is playing on his phone. He's not listening. It's day 6. And so even though the language of the note was he's not participating, he's playing with his phone, do we have to view that as a note that really means he's made up his mind and just is not talking to us anymore? Is that what that really means?
Well, I have a couple of responses. I think that first of all, the question is whether the trial court's decision was motivated by what was the impetus for the trial court's decision? Because here we're looking at whether the court abused its discretion. That is the question at issue. So we look at what motivated it. Now, that's not to say that the motivations of the jurors who complained aren't relevant. I mean, I think that sort of, plays into it. But ultimately, what was the reason for the court's decision to remove this juror?
You'd agree, for example, that if it were one of the counsel who said, let's remove this juror, he's a holdout, that would be relevant too. I mean, if the judge responded to that and said, yeah, you're okay, let's remove him, that also would be an impetus that's not the appropriate one, right?
Right. I mean, the position of the parties is something the court needs to take into account as well. But I do want to, and I wanted to address the timing issue, because although in Israel, there was much shorter timing involved, there, as here, the juror at issue had assured the judge that she had participated. I've participated in deliberations. I'm an active participant. And in fact, in Israel, the juror tells the court, they are bullying me, essentially. They are trying to pressure me to agree with them, and I don't want to. And so the issue of whether the juror was a holdout actually came to a head and was presented to the court. Here, of course, we have juror 15 who assures the court, yes, I'm an active participant as well. But it's the court's discretion to judge credibility. And just as in Israel, where the court didn't credit those representations, here the court was well within its discretion, having viewed juror 28's voir dire, interviewed her, having looked at the notes from both jurors 28 and 13 to say, well, I don't really credit that he's been an active participant. I credit these other jurors. Or, alternatively, okay, whatever may have happened, it is clear now that juror 15 is not willing to participate.
Yeah, so, I mean, how could we side with you on the first thing? She doesn't make a credibility finding like that, right? She doesn't say something like, I don't believe him when he says he was participating, that he's been participating.
She doesn't make an outright, an express credibility finding as to juror 15, but she does say, I've got these two jurors who have both, come to the same conclusion. And I think she does credit that that's what's happening, because her ultimate conclusion is that, in fact, he's not deliberating.
Yeah, but that gets me back to the question. I had thought I heard you answer this earlier, but like just separate out two different scenarios. Scenario one, the Israel scenario, somebody isn't engaged. A judge makes a credibility finding they have not been deliberating, period. Not from the beginning. I don't credit their assertions to the contrary. Situation number two is what we have here. And it's somebody says, well, they've sort of stopped deliberating for the last day or two, but nobody's saying he didn't deliberate from the outset. Nobody's saying he didn't deliberate the first 3 or 4 days. We have only one person's asked about that, and it's him, and he says, yes, I've been actively participating the whole time. So A, how could we draw a conclusion that the trial court's found he hasn't been deliberating for the first 3 or 4 days, 5 days, when there's no credibility finding like that, and there's no evidence that would support a finding like that, unlike Israel? And B, and this is kind of the question I thought I had asked earlier, what if the evidence were, I participated for 4 days. Let's just say he's being totally forthright. But I'm shut down, Judge. I'm done hearing listening to these people talk. It's been 4 days back there. It's been 5, 6. I mean, I know some of those were partial days. The first day was only an hour, so we're only barely into the 6th day. So really 4 days and change of full deliberations. I listened to them ad nauseum, and I'm done. I'm done listening to them. I've done my part and I've reached my conclusion, and I'm not interested in deliberating. And I thought you told me you could not deliberate, you could not remove that juror, but maybe I misunderstood.
No, I think that is correct. If the reason for removing the juror is that he's, he is impeding the deliberations because he's reached his own conclusion, and if the removal is because he's a holdout, then I think
Just because he's not deliberating.
I think if he's put in a good faith effort and there's evidence of that he has engaged and he has carried out his duties as a juror, then I think removal probably would be inappropriate. But, in this case, and it's true that there's no credibility finding as to whether, in the first 4 days or the first, let's say, 2 days, because we know for a couple of days now that he's not been participating. So whatever happened before that.
We have one juror saying that's been going on for.
We do,
days, right?
and that juror was credited, and that juror was interviewed, was, questioned.
You think the judge credited that he hasn't been participating for a couple of days? I just don't know where we find that credibility finding.
I think he credited the juror, as a general matter. He credits her representations. He's had a chance to view her, to see her demeanor. And Judge Brandt, has had a chance to view juror 15 and to view his demeanor. And, I think that, of course, given the entire context where she has voir dire juror 15 the day before, and all the parties were on the same page that they didn't believe him that day. I mean, that also kind of plays into how she views his representations before the court during the voir dire on December 14th. But
I took your opposing, so I guess I have two more questions and then I'll try to let you go. First, what is your reaction to the DC Circuit in Brown makes a big deal about these disagreements with jurors will often manifest themselves with the disagreeing jurors saying, oh, they're just not participating. They're not listening to me because I haven't convinced them. So why isn't that a reasonable possibility of what's going on with jurors 28's assessment of juror 15?
Well, I think we really don't know from this record what juror 15's views were. We don't know what any of the jurors' views were. None of that was presented in the record, and for good reason. The court cautioned the jurors not to reveal those things. So I think it's speculative to suggest that juror 15 was not with the majority or was with we don't know. It's quite possible
He
that
says when asked why are you no longer deliberating? I don't remember the exact prefatory question, but his answer was, well, because I've got my own little idea and I think I'm going to hold on to it. That sounds an awfully lot like I'm in disagreement with my fellow jurors. I'm not saying that's the inevitable reading of it. It sounds like a pretty reasonable, I think it's the most likely reading of that, and at least a reasonably possible reading of that.
Is it a possible reading of it? Yes. But are there other possible readings? Sure. I think it's quite possible that this juror maybe was with the majority, but then when it came time to take a vote, didn't want to pass judgment, right? Didn't want to be part of this process condemning somebody. So, I mean, that's very much, and we know that he said, I have an issue passing judgment. And the jurors who wrote notes indicated that, he had an issue with the process as a whole. So this, it's quite possible that was going on.
Don't you think that question about passing judgment, the way that it was posed by the trial court, implied passing it, like convicting someone?
I think, juror 28 sheds light on this. There's some ambiguity in what passing judgment means, perhaps, but juror 28 sheds light on this. She indicates to the court that juror 15 has said, I can't make any decision, period. So it's not that, he's, again, we don't know where he falls. We don't know where his views align.
Do you read anything into what I was describing to your opponent earlier, this note about do we have to be unanimous in acquitting of second-degree murder before we can move on? Because as I said before, the way the question was phrased, it's like everybody or most people wanted to acquit, but there were a few people or one person who didn't. And so I wonder if that tells us anything about this point you were just discussing, which is the difficulty juror 15 describes in reaching any decision at all, one way or the other.
Yeah, I think it's difficult to read anything into that note. It's quite possible, as the deliberations were described, it sounded like the first few days the jury was methodically going through the exhibits one after another. And then perhaps at that point, when they sent that note, they came to a point where they said, okay, it's time to actually sit down and look at the charges and take votes. And so, the opening question was question on the order of considering the charges. So, they were wondering, how do we do this? What's the process that we need to do this? But, even if I think even if we want to read into it, some as shedding some kind of light on how they were leaning, again, I think it's quite possible that juror 15, could have been in favor of acquitting at that point, right? The question was, do we need unanimity to acquit? So it's very difficult to say what was.
Do you read anything into the end of the timeline, which is that on the Monday of the final week, the court tells the jurors to start over again because now there's an alternate among them, so they deliberate pretty much all day. They start a little after 9, and then they come back the next day at about 1:30, and by 2:30 they have a verdict. So it was pretty quick. It was, a day and an hour. Does that tell you anything about whether?
I don't think it cuts against our position. I think the court instructed them to start over from scratch. You have to start on a clean slate and you may change your position. So they then engaged in several hours of deliberation. I don't think it was, a sudden verdict, which would have been, obviously a little bit more suggestive of the fact that they were, it was 11-1 or whatever. But I do want to point out that all of this court's cases on this issue, nearly all of them, Shodakari, Israel, Brown, Braxton, all involved a holdout juror where it was made known to the court that the juror was a holdout. And some of them, as I've said, Israel, involved a juror squarely presenting to the court that she was being pressured by the majority. In each of those cases, though, this court looked at what was the impetus for the removal. And despite the fact that there was a holdout and there was a dissenter, in each of those cases, the trial court had a reason to remove the juror apart from the juror's views on the evidence. And I think that that's what was going on here. Judge Brandt was very concerned about juror 15's inability to exchange ideas with his fellow jurors, to engage in the process. And throughout the transcript, she points to that. She says, issue number 1 is the allegation that he is unwilling to participate in deliberations. That's on page 32. She goes on to say that the fact that he can't deliberate is more powerful even than this idea that he can't pass judgment because he's supposed to be able to sit back there and deliberate with his fellow jurors. So, and that's on page 57. So I think that's what her concern was. That was the impetus for the removal. And I think because the court had a firm factual basis to make that finding that he was unwilling to participate, this court owes substantial deference to that. Hinton tells us that if the trial court makes a reasonable judgment, that this court cannot second guess that. And I think that this record provided a firm factual foundation for that judgment. If there are no further questions.
Let me ask you something completely, well, not completely, but by and well speculative. How do you think how do you think juror 15 got through the initial voir dire?
I don't know. I did look back on that initial voir dire, and I think, there just wasn't a lot of information presented, as is often the case. Not much information came out about him. So I don't know what happened. I think it's possible that he just didn't really understand the process, and that wouldn't come out in the initial voir dire because questions about how jury deliberations work aren't presented at that point.
It's fair, but you'd always have the standard question about could you pass judgment or could you convict? Some form of this. And so you think it's just like the juror note that came later saying he just didn't understand what was going on and thought he was going to be part of a majority verdict instead of a unanimous one.
I don't recall that the judge asked, a question about whether you could pass judgment. But most of the voir dire questions go to potential biases. And I don't think that was particularly an issue here. It was just simply, as presented by jurors 28 and 13, a misunderstanding of how the process works and how, what it means to deliberate with a jury of 12 people. So that's what I took away from that. Okay. We would ask this court to affirm. Thank you.
Counsel? Mr. Clark, we'll give you a few minutes.
Thank you, Your Honor. So just to address your question, Judge Howard, juror 15 was asked, there was the standard question about whether he could sit fairly and impartially. And as I put in the transcript and page 21 of my brief, he was asked those questions and he said he didn't respond that he had any religious, moral, or other issues with passing judgment. And to, I think, Judge Deal, your questions about what it means to really deliberate. Yeah, I mean, there is a vanishingly thin line between standing on your morals and standing on your position and refusing to deliberate. The Supreme Court has stated that deliberation means just when you enter the jury room, it is your duty to consult with one another, to consider each other's views, and to discuss the evidence with an objective of reaching a just verdict if you can do so without violence to that individual judgment. And so I think that that standard really only means that you have to enter into the jury room with the intent to at least, listen one time around. But I do not think that deliberation has to be anything more than that. And I found it very, ultimately, I think where this court should come down is, as government counsel has admitted, it's possible. The interpretation that Mr. Jordan advances here is a possible interpretation. And it is possible that that is the impetus, and that is all that is required under the standard, is just the possibility.
I mean, what's your response to Ms. Gabriel's argument that when we ask what is the impetus, we're really asking about the trial judge's motivations? Is that the right way of thinking about it?
I think you have to go back at least one step further as to why it even came into the purview of the trial judge in the first place. And so that goes back because whether it stems from it has something to do with why it comes to the trial court's attention. It's not just what the reason that the trial court gives. And the other issue is that while absent the constitutional ramifications, it might be that the trial court's decision is not an abuse of discretion, except that because of the constitutional implication, the trial court's discretion is strictly confined at that point. And so once you have any reasonable possibility on the record itself, the trial judge has no option but to consider it. And while the trial judge the trial judge made no specific factual findings about Juror 15's or Juror 15's credibility, as this court pointed out. But more importantly, the trial court did not make a specific factual finding as to the ultimate issue at hand, which was the Sixth Amendment issue and what the impetus was. That wasn't a factual issue that the court acknowledged or dealt with. And that would have been the key factual issue if this court were to be giving it any sort of deference or have to consider. And so it just appears that, the issue was missed on this record. And the
trial judge did, in describing the juror notes, say something like, the note from the first one, I think that was 28. This juror is emphasizing process. It's this juror seems not to have understood the process and to be participating. I mean, the court did seem to credit that. I give you that the court didn't say I credit juror 28 even after conducting the colloquy with juror 28, but certainly seemed to do so implicitly, I would say.
I think that those notes influenced the discussion, but what I do believe is key is that when the court, the one note that makes the point clearly is Juror 13's note. But she never speaks to Juror 13, and we actually don't have confirmation that Juror 13 was talking about Juror 15 because it doesn't mention. And again, though, the note from Juror 13, if we look at it from the point of view as it's sort of explained in Symington and Litwin and Brown, is that the way these issues come up when the allegation is that somebody is not deliberating, that is often an underlying sign for disagreement itself. And then when the court talks to Juror 28, Juror 28 talks a little bit about the lack of participation, but Juror 28 doesn't say, oh, well, this juror said, I have a moral issue. I can't pass judgment at all. really, I think the way to interpret juror 28 is that juror 15 is back there, is maybe not articulating himself well, is frustrating the other jurors, and is saying, and they're asking, well, why not? Why not? And he's saying, well, as juror 28 quotes him to say, well, let me think. I'm trying to think. I'm trying to think to explain it to you. But that's not a lack of participation. And that's not a, I have a moral issue with passing judgment. It's, no, I'm trying to think and explain myself. It has something to do with the merits. Maybe I can't put my finger on it, but we don't require jurors to be articulate. We don't require them to convince other jurors. And I think that juror 15 is doing the best he can. And what comes through in the only other juror that the judge speaks to is not a inability to make any decision based upon some sort of moral grounds or religious affiliation. It is I'm having trouble explaining myself. And ultimately, if I can't decide, well, that's a vote for not guilty. I mean, we have the jury instruction that talks about if you go back and you pause and you hesitate over a very serious issue, then that is something that we might call a reasonable doubt. And maybe juror 15 can't put his finger on it, but he is pausing, he is hesitating, and he is reluctant to go and vote guilty.
Yeah, all of that, I'll just say this, all of that is so, except that there is this overlay of the trial judge not really believing juror 15 and what he says. You know, his financial discussion was a ruse in the trial court's view. And so was what he had to say in explaining his so-called non-participation. She just didn't believe it. And so, you know, to the extent that he conveyed that he just couldn't put into words, I'm not sure the trial judge believed that, and that counts for something, I think.
I think that the fact that the trial judge didn't believe him has to do with that she did think it was a ruse, because if it's a ruse, the trial judge still had to wrestle with why this juror was presenting a ruse, or maybe giving some sort of false account of what was really going on. So the factual issue that the court had to deal with, it was not whether juror 15 was being truthful or had veracity, but why juror 15 was now saying the things that he was.
Thank you, counsel.
Any other questions? Thank you.
The case will be submitted, and we will move on to the second case for this morning. 24 CV 957, DARRYL Jennings Jr. versus Howard University. Counsel, whenever you're ready.
Yes. Good morning. May it please the court, David Branch for the appellant DARRYL Jennings. The first issue in this appeal is whether Howard University breached its contractual obligations and deprived Mr. Jennings of a fair doctoral evaluation by failing to follow its own established examination procedures. The trial court found that on the breach of contract claim and the promissory, breach of contract claim, that only one of the issues raised by Mr. Jennings would be permitted to proceed to trial. And that was the issue of whether one of the professors, Dr. Hutz, was permitted to give the examination to Mr. Jennings when he had not been a faculty member of the record. The trial court improperly limited all the other claims related to the breach of contract issues, and that included Mr. Jennings' allegations that he was interrupted during one of the exam procedures, improper conduct by one of the professors, Dr. Ovalabi, the entire review process after it was determined that he would not succeed, he had not passed the exam, procedures such as an open book versus a closed book examination, and lack of an opportunity to review the material before the examination was actually administered. Some of the examinations were administered. So the issue goes beyond just this single incident of one professor who was not the professor of record being allowed to administer the examination. And the trial court erred by granting summary judgment on all these issues and only permitting a limited issue to proceed to trial.
You know, I thought on the professor, I don't know how to pronounce his name, Hubsch.
Hoops.
I thought the issue with him was that he was not a member of the department faculty, the mechanical engineering department faculty. It was that issue where the court allowed the claim to go forward, except that it then limited your client to nominal damages. Isn't that
Yes.
right? I thought the trial court kind of dispensed with the instructor of record issue earlier than that.
Yes, Dr. Hutz was not a member of the department, mechanical engineering department. I think it was mathematics.
Physics,
department.
I think, yeah.
Okay.
Right.
But yes, that's the only issue the court permitted to proceed to trial. And of course, Your Honor, you're correct. The issue that was permitted to go to trial was this limited breach of contract or breach of implied covenant of good faith and fair dealing. And the damages were limited to nominal damages, which I guess could be $1 or some nominal amount. When Mr. Jennings had alleged that as a result of the breach and being discharged from the program, he had to re-enroll at the University of Virginia. He lost 4 years of academic work. He suffered emotional harm or emotional distress, reputational harm, and the trial court determined that the only damages he could claim would be nominal damages.
You then voluntarily dismissed that claim, though.
We voluntarily dismissed the claim, yes, as it relates to, because the damages were limited to nominal damages.
For whatever your reason, you dismissed the claim, and I don't see how you can appeal a non-adverse ruling. That's one of the quintessential requirements for appealability, is that the ruling needs to be adverse to you. And the judgment that you're appealing, there's an underlying question about what damages you could get, but is the dismissal of a claim that you voluntarily dismissed. And it also, I mean, just as a practical matter, it would run against all of our interests against piecemeal appeals to permit an appeal like this to move forward, because you could have gone to trial, established liability, and then appealed. If you had established liability, you could have appealed the damages ruling, and that would have been totally proper. It would have been a way for you to get your money if you were entitled to it. But it's not like every time you get an adverse interlocutory order from a trial court, you get to dismiss your case, bring it up to the Court of Appeals, and then get it back where you started, because then we'd have piecemeal appeals all the time.
Your Honor, the ruling that the damages, that he would only be entitled to nominal damages, we construed that as an adverse ruling. I mean, we would have to go to trial and get an award of $1 and then come back, then file an appeal.
Yeah, that's right. I mean, there's good reason for that, because if you lost at trial on liability, well, then that appeal is irrelevant, and we're done. And so we don't deal with piecemeal appeals generally. This is true of every evidentiary ruling in limine where there are bad rulings for you. You don't get to dismiss your case and then bring it up to the Court of Appeals and say, hey, reverse this evidentiary ruling. You know, these trials and appeals would go on forever if we did that. You got to bring it all at once. And if you wanted to complain about the damages, bring it after you secure a judgment of liability, which might be mooted out if you don't manage to do that. I mean, that's the practical reason behind it.
We construed the trial court's decision that the damages would be limited, would be just nominal damages as an adverse ruling. And that's why, you know, a decision was made that we would appeal basically all the claims that were dismissed, as well as this.
Yeah, I don't mean to beat a dead horse. I mean, it's definitely an adverse ruling. It's just an adverse interlocutory ruling. And in order to get an appealable judgment, the claim need to be resolved, and that claim was resolved via something that was not adverse, which was a dismissal at your request. And that's,
And maybe you also could just briefly address on the merits, how would a jury, without speculating, have figured out what damages to award your client? My initial thought, I have to say, when I read the briefing about the court's ruling was, well, at the very least, it seems Mr. Jennings should have been able to present to the jury evidence about what tuition was in the new program in which he enrolled. And then I thought, wait, maybe there was none, because lots of graduate students get a free ride on tuition, plus they get some stipends. So I'm not even sure that's a fair assumption. So, I mean, would it not have been unfair to the other side for your client for the first time at trial to start quoting some dollar amounts about what his economic damages were, or what his pain and suffering or humiliation or reputational harm damages were? And I think the record indicates your client was working at the time, so it's not even, I mean, you can't even jump to the assumption that he was prevented from gaining employment because he was back in school again. So how, without speculating and without unfair surprise to the university, could he have presented some estimate of those damages at trial?
So the first point was he had to re-enroll in the program, essentially start over at the University of Virginia. So he lost 4 years of academic work at Howard University. He had to restart completely at the University of Virginia.
Right, but for all we know, he didn't spend any money. I don't know whether he did or he didn't. Maybe he got free tuition at both places. Maybe he was working while he was in school and making money, so he wasn't without income. I mean, we don't know any of that, do we?
We don't know. Well, in terms, he did work while he was at the University of Virginia, but he had to be admitted into the program, and obviously had to progress successfully through the program. Now, he did allege that he suffered reputational harm. He had never been dismissed from any academic program. He gave an estimate of what, in his answers to interrogatories, he gave an estimate of his damages.
what was it? I don't recall seeing that. What was his estimate of his damages?
Well, he alleged in his answers to interrogatories, or made a demand for $5 million.
So help me, because my question around this, or what I'm struggling with, is the issue was there just was not a lot of evidence released in leading up to all of this and not coming out through the discovery process. What would he have been able to put on to establish the damages beyond even articulating a theory of it? If he, he's definitely said 5 million. How is he going to be able to substantiate that?
He testified at his deposition that because of that there's a value, obviously, in having a PhD, that his salary would have increased where he was working had he received the PhD. And so his salary was reduced because he did not have a PhD. So there would be the difference between what he could have earned had he completed the program and had his PhD, and what he was making because he did not have his PhD. So that's one measure of what he lost in wages.
Did he put those numbers out?
He did. He was testified to that at his deposition. Plus, the harm that he suffered emotionally, as well as a result of being dismissed or discharged from the program, and having to enter the program at the University of Virginia.
Did he have a doctor or anyone that was going to testify about that emotional harm?
He did not have a doctor. I don't think he was seen by a doctor, but he did not offer any type of expert testimony on the emotional harm. But it's not uncommon for people to say, because
No,
that
it's
type
not,
of
it's not
evidence
uncommon
without
at all.
doctor.
I'm thinking back to a time where I used to deal with a lot of DC Human Rights Act cases, and how we used to evaluate those kind of damages, and medical evidence made them much stronger. Gave us much more room to put up a lot more. Let me ask you, is he really arguing that it's reputational harm? I mean, I get the basic point of I was dismissed from a PhD program, and that in some sense is harmful regardless. but he successfully got into University of Virginia, which is a very prestigious school. Is he arguing at all that there is harm based on that beyond the delay and just the mere fact that he was dismissed from the program at Howard?
He is arguing, or he did argue, that he was harmed. It harmed his reputation. He went to a very, I guess, prestigious undergraduate degree program, then selected Howard, and then he's discharged by Howard without Howard following any of the procedures that it promised to provide to him, both having the professor of record administer exam and then all the other issues when he tried to challenge or appeal the process.
So I found it particularly interesting, having gone to Howard myself and taken the undergrad comps. It seemed like we're reading a lot into this administering. Could you briefly, and you've talked about it in your brief, could you briefly help me understand why a professor administering it, if the professor is just administering a written exam, really matters, how that's more than being a proctor? And then along those lines, what would have changed? Because it seems like he failed several subjects.
Well, in terms of being administered, the definition of administered and why it's important in a highly, scientific type degree, just having the professor spend a semester saying, these are the most important issues. This is the material that we're going to cover, that I think is important for you to pass this course. Having that professor be the person to actually administer the exam, it makes all the difference in the world, as opposed to having someone who didn't teach the course, who may believe that there's something else or a different area that should be emphasized, having that person create the exam, and administer the exam. And that's the position that Mr. Jennings found himself in. He's pursuing a doctorate degree and he's sitting for an exam, and it may be that this is the first time that he's seeing the material that he's being questioned about on the exam, and then he's given a failing grade.
Is it the first time that he was seeing the material that he's being questioned on the exam? You said it may be. That seems like a huge difference if it actually is. It wasn't perfectly clear to me in the record.
Well, I mean, the fact that the score that he received on the exam, when he completed the coursework, he received A's in these exams, A's in these courses. And then someone else comes in and gives an exam and he's issued a score, a failing score on these examinations. Yes.
I thought I read in the record that the professors in question here, the one who was not an instructor of record, had provided to the examinees before the exam a list of topics to be covered.
Yes, Your Honor, a list of topics, but how can that compare to sitting in front of a professor and doing coursework over the period of, 4 or 5 months during the course of semester, saying, okay, I'm going to cover topics A, B, C, and D on this exam, is very different than actually doing the coursework leading up to the exam. And that's the issue. How can you administer an exam to someone and they have not gone through the coursework, and all they have is just a summary of the topics that are to be considered?
Well, in any event, I think you didn't get to address the other part of Judge Howard's question, which is a question that concerns me too. And it's that even if you disregard the failing grade.
Excuse me, I just spilled some water.
Oh, sure.
I want to show up your equipment. So
Those tiny cups, tough to deal with.
you were saying.
Sure. Even if you disregard the failing grade that Mr. Jennings got on the portions of the comprehensive exam developed by the professor who was not a professor of record and the professor who was from the physics department and not a member of the mechanical engineering faculty, he still failed other portions of the exam and thus still would have failed the comprehensive exam. So I guess, and not to put words in Judge Howard's mouth, but the question seemed to be, so where's the harm? Because he failed the other portions anyway and would have met with the same fate, which was termination from the program. What's your response to that?
The response is, one part of his claim is that I was not, the evaluation or the review process for the exams was not the standard review process for the exams. He asked to see the results of the exam. There was an issue with that. He asked for a review. There was an issue with that as well.
You only asked for that for two aspects of the exam, right? Go ahead.
So that would be part of the issue, was that they didn't follow the normal process even in reviewing the exams. First, he wasn't given the material to before the exam. You had different professors administering the exam. And then even in the review process, Howard didn't follow the normal procedures for the review process. So we have occasion after occasion after occasion where Howard failed to follow the procedures that it told the students that it would, graduate students, that it would follow as they matriculated through the program for the examination and the review process. And as a result, Mr. Jennings ends up getting discharged from the program. So we believe all these issues should have been part of the breach of contract claim that was permitted to go to trial, and not just limited to this one issue with the professor. The final point is the trial court also granted summary judgment on the negligent supervision and retention and tortious interference. And there was evidence in the record to support that this professor, Dr. Al-Balabi, first had influenced the decisions to terminate, well, to not terminate, but discharge Mr. Jennings from the program. And there was a record of students making complaints about his behavior. He interfered actually with the exam, one of the examinations that Mr. Jennings was sitting for. There was sufficient evidence for that issue.
Did he? Mr. Jennings didn't report that himself at the time, did he?
He did not report that issue, but it was later reported when he raised all these issues before he was actually discharged from the program. Just like to reserve a couple of minutes, please.
All right, thank you, counsel. I know we've taken you over your time, but we will give you a couple of minutes on rebuttal. We will now hear from counsel for Howard University.
May it please the court, Daniel Previs for appellee Howard University. Mr. Jennings failed the comprehensive examinations 2 times.
Counsel, sorry to interrupt at the beginning, but are you representing all the appellees, or are you splitting time with?
Only one appellee, Howard University.
Oh, I thought there was an individual appellee. At least we have it.
Dr. Owolabi as well, yes.
Right, okay.
I
And
represent him as well. I'm
understood.
mistake.
All right, thank you, counsel. Go ahead.
Mr. Jennings failed the comprehensive examinations 2 times. I can't emphasize enough how vital it is to Howard's interest to ensure that PhD students have a command of the basic disciplines in mechanical engineering. Literally, turbines can explode, planes can fall out of the sky if you have someone with the stature of a PhD who is not qualified. Now, we've heard a lot of stuff about rules and so forth. The bottom line is there's not an iota of evidence in this case that any examination was not graded fairly, was not prepared fairly. It's all waving the hands and vague allegations. But the bottom line is that Mr. Jennings failed the examinations, and he hasn't reckoned with that. Instead, he's tried to latch on to all these arguments. And we just heard from counsel that there were occasion after occasion when the university did not follow its rules. Not so. He raised a lot of arguments, and we knocked them down one by one, like dominoes, in the Superior Court. That led the court to find that there was no claim there. Now, in particular, there's a lot of factual allegations that are made that are just not supported by the record, and we documented that in our briefs. And the one that is probably the most glaring is this claim that only instructors of record could give exams. Okay, well, it's undisputed that no document was ever given or published to students with any such rule. That was an internal guideline, and the law is clear that internal guidelines like that are never distributed are not contractual. Clampett versus American University is the key case in that regard. As a matter of fact, it is undisputed that even after these 2013 guidelines were issued, they were never followed. There was never an instance since even in the September 2013, February 2014 period when only instructors of record were used. So where does this come from? This is not a contract. There's no basis for it. And I think this was really conceded on appeal, because in the appeal briefs of appellant, all you hear about is breach of covenant of good faith and fair dealing. That's all you hear about. A breach of covenant of good faith and fair dealing is an important principle, and it ensures that a contracting party will do nothing to undermine the spirit of the agreement, will not act arbitrarily, will not act in bad faith. The covenant of good faith and fair dealing, it's not a panacea. It's not a grab bag where everyone can find anything they want. It has to be linked to something in the actual contract. The actual contract here were the graduate school rules and the department handbook, which say nothing. And as a matter of fact, they preserve great flexibility to the department to determine what the format procedures should be for examinations. It says administered by the department faculty. That's all it says. There's nothing there. There's no invisible ink there that says only instructors of record. So there was no contract claim. There is no breach of covenant of good faith and fair dealing. Then we get to the Hupsch claim. And this is very interesting because there was no evidence presented in the court below to provide a basis for estimating or quantifying damages. As a matter of fact, at his deposition, when Mr. Jennings was asked, well, how do you determine your damages? He says, I would need an expert. I would need an expert witness to compute them. And of course, he never provided an expert witness. And some of these things you've heard here today just don't make any sense. He says emotional distress damages. Well, there's no emotional distress damages available as a matter of law for a contract breach. So by him saying, I had emotional distress damages doesn't help him on the Hupsch claim. What we have ultimately—
I think he also said reputational harm.
Reputational harm, well, he did nothing to quantify that.
I mean, it's tough to quantify that. I mean, you don't think a jury could hear testimony that somebody was kicked out of a PhD program, assuming that they believed wrongly that Howard did not do what it was supposed to, that he had to restart a PhD program, will take him another 4 years at least to finish that degree. And that it's just going to be a black mark on the rest of his career. And while that you could have an expert to bring in exactly how that reputational harm might sort of impact economic income later in life, there's still certainly some value that a jury could attach to that reputational harm alone. And it's embarrassing. People fail the bar sometimes. You have high-profile people failing the bar, and it's embarrassing that they failed the bar. And they could attach some value to that, I think. And I don't know if an expert could do any better than a jury.
Well, you have to have some basis to determine reputational harm, to quantify it or estimate it. In this case, when we filed our motion in limine, there was no argument made for which there was evidence. You don't just say there's reputational harm, you have to have evidence. Did nothing to quantify that, to estimate it, did not even argue to the trial judge that there was some reputational harm. So this is an argument that he's waived by not presenting it. His opposition to the in limine motion was extremely minimal, did not get into this. I invite you to look at that. It's in the appendix, and you'll see he didn't raise any of that. He didn't raise that issue. Some of the other things with respect to the Dr. Hupsch claim, the university is responsible for substantial compliance. Now, Dr. Hupsch was in fact the instructor of record. The evidence, even plaintiff acknowledged that he was the most qualified person to teach the exam. If you look at the department handbook, it actually indicates that the math courses will be taught from the physics department. And most of all, he never objected to this. There was a complete waiver here of any objection to the composition of the committee. This is a post facto argument that he's pulled out of whole cloth. There was substantial compliance. It made sense. It didn't make sense to use anybody else. The department had been using Dr. Hupsch for years, and it's substantial compliance. The court below was wrong not to grant summary judgment on that claim. Also, it's important to remember that what we have here is an evidentiary ruling by the trial court. The trial court did not rule that no evidence of damages could be presented. Quite the contrary, the court said, you can present any type of damages evidence you have as long as it was presented in discovery. So there was no barring of evidence as long as it was in discovery. Now, this court has been clear, like Jung versus Jung is an example of a case that emphasizes that courts have a duty actually to prevent discovery abuses. And this was a discovery abuse here. And that's kind of evidentiary ruling is reviewable only for an abuse of discretion. There's been nothing to suggest that there was an abuse of discretion here. So on that basis alone, the appeal of the judge's ruling should be set aside. I could go on and on about incorrect factual assertions by counsel. Assertions that people weren't given an opportunity to review exams. They weren't told in advance what would be on the exam. Those are all negated by the undisputed evidence in this case. I'd be glad to take any other questions the court may have.
Thank you, counsel. I think we have your argument. Mr. Branch will give you a few minutes in rebuttal.
Thank you. First, I'd like to address the issue that the trial court did not limit evidence. The trial court ruled or held as a result of the motion in limine that any damages would be limited to nominal damages. So this claim that somehow the trial court did not limit evidence, I mean, it's just inconsistent with the trial court's decision that any award of damages would be nominal damages. There was no abuse of the discovery. This claim that somehow Mr. Jennings failed to respond to discovery is just simply not true or inaccurate. Mr. Jennings detailed how he was damaged as a result of being discharged, being removed from the program, how it damaged his reputation, how it would require him to enroll in another program and lose 4 years of academic work, as well as the impact he testified at his deposition, the impact that it would have on his earnings as well. So Mr. Jennings did present evidence of how he was harmed as a result of the breach, and as well as the reputational harm that he suffered. And Mr. Jennings has always argued, that was really the driving force behind the case, that as a result of Howard's decision to discharge him from the program, he suffered reputational harm. He was required to re-enroll in another program, essentially start the whole process. His whole career not only has a black mark on it, but also he's set back by 4 years in getting his degree. Those are the final points that I wanted to raise. Thank you.
Thank you, counsel. The case will be submitted. And we will hear argument in our third case this morning, number 25 AA04, Bloomberg Inc. versus DC Office of Tax and Revenue. Whenever you're ready, counsel.
Good morning, still morning. If it please the court, Stephanie Ann Lipinski Galand on behalf of the appellant Bloomberg Inc. I request 4 minutes for rebuttal, please. This matter before the court is a question of the Office of Tax and Revenue's interpretation of the council's creation of QHTCs, which are qualified high-tech credit companies, is a regime that the council created to bring tax benefits to both corporations and pass-through entities known as unincorporated businesses in the district as well, to encourage those types of businesses to come into the District of Columbia and do business, right? To increase its high-tech base, okay? Everyone agrees that as part of that initiative, that the council intended that they would be able to take these benefits, which are income tax benefits, which are basically a reduction of your income tax that's imposed upon the income that you earn in the district in your high-tech activities, sales and use tax exemptions, property tax valuations, and training credits. And the training credits obviously go towards the income tax as well. Everybody agrees that this was proper and that the council had every right to do this. So there's no question as to the QHTC benefits that were established. The controversy here focuses on the fact that OTR erred in its interpretation of the benefits that come from the QHTC, specifically as it has to do with pass-through entities or unincorporated businesses. The district defines an unincorporated business in the District of Columbia as a partnership, a LLC, any type of pass-through entity where the income derived from the activity of the entity that's located in the district is passed through, or that income is passed through. So there's.
I thought, so let me, just to look at the statutory language and tell me where I'm getting this wrong. I'm looking at 47-1808.01. The term unincorporated business does not include a qualified high technology company. Is that right?
That is correct, Your Honor. What
Okay.
happened is when the council passed the high-tech credit thing, it was focused on C corporations originally, which are basically your standard corporation. And then it realized through testimony that's included in the exhibits and in the appendix that a lot of high-tech companies came in and said, we don't operate as C corps. So by only giving this benefit to C corps, you're totally excluding all these pass-through entities, which is the preferred formation for most high-tech companies. So Councilman Evans at the time, there's a large record in the appendix where he brought these people in so that they could give them information on how they could remedy this. So the council, for whatever reason, and it's not clear in the record, tried to fix this inequity of the application of the income tax benefits, which is a reduction of the income tax on income earned in the district to pass-through entities, UBs, by removing them from the definition of a UB, an unincorporated business, a pass-through entity. The goal was to allow them to be able to have a reduction or a benefit for the income tax that they earned because of the fact the C corps were getting that benefit, and yet the pass-through entities were not getting that benefit.
I mean, I hear you, but in a debate between purpose and statutory text, the text tends to win. And saying it was a whoopsie daisy tends not to be a way around it. So, I mean, maybe the big mistake by the council, but like, here's the statutory language that I've got in front of me. And
But-
it seems to answer the question.
I understand your question, Your Honor, or your statement, Your Honor, but here's the issue, is that the statute, the withdrawal of QHTCF from the definition of that is ambiguous on how do you get that income tax benefit. That was the intent of the council. It's ambiguous as to how this benefit is to be is to be applied to the unincorporated businesses or the pass-through entity. And it is that ambiguity that makes you have to go to the council's intent and look at what the council's intent was.
I don't see the ambiguity. I see 1808.01 saying that QHTCs are not unincorporated businesses. And so I looked at 1803.02 and it tells me that it's not in the list of exclusions that you can make because it's not, there is 02D says you can write off the distributive share of an unincorporated business, but I know QHTCs aren't that, so it doesn't fit that exception. It doesn't fit any other exceptions, so I'm done. I don't see the ambiguity in that language.
The ambiguity, Your Honor, is that how are UB QHTCs supposed to receive the benefit?
Yeah,
If
that's
you
not a
say-
statutory ambiguity, though.
If-
That's the world's not fair kind of ambiguity when they wanted to do us a solid and they failed to do it. I mean, again,
Well, I mean, the benefit is they don't pay the franchise tax. That's a benefit,
Well,
right? I mean, I get that the partners, Bloomberg Inc. ends up paying some tax, but that the partnership didn't pay any franchise tax, doesn't pay any
the
franchise
District of
tax.
Columbia is what is known as an aggregate, is an entity-based, entity theory on partnerships, on pass-through entities. And it was cited in the district's brief. And under entity theory, it is the entity that is responsible for the tax on the income that's paid. And here's where the ambiguity, here's where the misbalance or the contention happens, is that the district, if you look at what they do on their returns and everything else, the instructions they give on their returns, they're basically saying, okay, we recognize you're a QHTC. For all intents and purposes, if you look at the returns, at the emails that will go back and forth between the district and the taxpayer, it basically says, okay, we know you can't file a UB return because you've been taken out of the UB, but we want you to file now a partnership return, right? Instead of that, and you circle that you're a QHTC so that you can get the QHT benefits, because the district is very clear. The entity, the pass-through entity, the Bloomberg LP, still can get the sales tax, and it's still a qualified QHTC. It gets the sales tax, it gets the property tax, it gets the training credits. The issue under the entity theory is that all has to be in the entity. That's why the District of Columbia made its decision. It is precluded from federal law from taxing partners, non-resident partners, right? It can't go after people that reside outside of the district or have nexus outside of the district. It can only tax DC citizens. So it came up with this, it uses the entity theory, which most other states use an aggregate theory, which all of the benefits and all the income and all the attributes passed down to the partnership. DC made the intent to do this entity theory for its partnerships and pass-through entities. If the district, this is where the ambiguity, the district keeps insisting that these entities are QHTCs, right? And that they get all the benefits from the QHTC, including the income, the sales tax, the property tax, the training credits. But now they're taking a position, oh, well, you can't get the income tax benefit because you can't file as a UB, right? So you're not filing under there. But what we're going to do is we're going to take this income and we're going to make you pay tax on that income. And that's where the problem goes, Your Honors, is that you tax the income. You don't tax necessarily the entity, you tax the income. And by they have admitted that there's continue to be QHTCs. that they get all the benefits of a QHTC, which includes a reduction of the income tax, right?
But for the status of Bloomberg LP as a QHTC, it would pay the franchise
It
tax.
would have had to pay the franchise tax.
That's the benefit, that it does not have to pay the franchise tax. That's why I'm not following your argument that there's no benefit. There is, but for the QHTC designation,
They wouldn't have to
they would pay the franchise
They
tax.
wouldn't have to pay tax on that income. That's the benefit of the QHTC.
The franchise tax, we're told, is not an income tax. It's a tax on the privilege of doing business in the District of Columbia. So it would pay the franchise tax.
But the whole issue is that you look at taxing the income. If you look over to the C Corp, right, that they had, which started this whole thing, the C Corps get that exemption. And you look at the language in the regulation and everything else, it is an exemption from the tax, whether it's the income tax for a C Corp or a franchise tax for that, you get the exemption. They are exempted, right? A C Corp, let's say a C Corp earns $1 million and it qualifies as a QHTC. It gets the exemption from paying the tax on that income. So the C Corp is walking off and not paying any tax at all on that $1 million. The council saw, oops, like you said, oops, that's my bad, or there's a bad there. They looked and they said, well, we have to treat these as the pass-through entities the same. So what they did was they said, we're going to exempt you from paying the QHTC, from paying that tax, from paying the franchise tax that the unincorporated businesses are subject to. The same thing that happens over at the corporate level, to basically say, we're going to let C Corps on the same QHTC, there's no special QHTC for corporates that they want to have for pass-through entities. So to say you can get that exemption, right? And you don't have to pay tax on that $1 million. But over here, because we excluded you from QHTCs from the unincorporated business tax, and that was our way of exempting you from that tax, right? You still would have had to pay that tax, but we're now exempting you. And it's almost like it's a gotcha moment, Your Honors. What the district is saying is that we're not going to, because of the pass-through special characterization that pass-through entities have, it's the same income here at the entity level that goes to the partnership. We can't tax you. We can't get a dime out of you for this money, for this income at the entity level. We're going to take that same income as it flows through. Now we're under an aggregate. Now the district switches over and becomes an aggregate theory for partnerships and says, we can't tax that $1 million that you earned UB in the District of Columbia because of because you're a QHTC, and we're going to remove you from franchise tax. But now we're going to track that same money. It flows through down to the partnership, and now we're going to tax the partnership.
I
That
get your
flies in the
point.
back.
This may not be the wisest tax policy or the best designed one, but it doesn't seem to amount, as you argue in your brief, to double taxation. There's no double taxation. And there is the benefit that the LP does not pay the franchise tax. And apparently OTR's position is there's another benefit in that it doesn't have to file the more complicated tax form. You only have to file the Form 65. So, I mean, these may be minimal benefits, but is it to us to go counter to the unambiguous statutory language and say that Bloomberg Inc. is entitled to deduct its distributive share when the statute seems to say otherwise? It says that share has to be from an unincorporated business, which the QHTC is not, and it has to have been taxed under this provision, which it wasn't because it doesn't pay the franchise tax. So how do we get around that?
Is a key principle of pass-through entities, Your Honor, both on the federal level and on the state level across the country. And that income derived from an activity from a pass-through entity, right? And then that's that same $1 million that gets passed through down to the partnership, that's the benefit of having that partnership, right? Or that pass-through entity, can only be taxed once. The Supreme Court has come out very clearly in Wynn and said that you can only tax it once. It's the same income.
I know, but where is the double taxation here? That's what I'm not understanding in your argument. I get that the situation is that Bloomberg Inc. is paying tax on its distributive share from LP, and it would rather avoid doing that and maybe wouldn't have had to do that if it had organized LP as a corporation instead. I get that, but it's paying only once and LP is not paying it at all. So where is the double taxation? I get your point about maybe this not achieving the fullest benefit the council had in mind, but where's the double taxation in that?
Double taxation arises, Your Honor, because the pass-through entity, the UB, it is a functional, it is as if the tax had been imposed and then they gave an exemption, right? So you only get an exemption if there is a base, right? It's like you can, and I know this is mixing taxes and I know this is really geeky here, but for instance, on a sales tax, it is imposed. Income tax is imposed, sales tax is imposed. An exemption, which is the thing that we're used to seeing most, that word used for sales tax, means you are still you are going to be taxed on that money. You're being taxed, but this exemption is now going to allow you to escape taxation on that.
Yeah, I know, I understand your argument finally. It took me some while to understand it. Your point is that they're taxed, but it's at a 0% rate. That's why you see it as double taxation.
It's being taxed.
But it seems that the structure of and the language of the statute is these entities are not unincorporated businesses, hence they're not even subject to the tax. So that I would say it's not a 0% tax under the scheme that they're subject to. It's just that they're not subject to it.
All right, so
They're not taxed at all. I as an individual am not subject to the unincorporated business tax. It's not that I'm taxed at 0%. It's just that that's not a tax I pay.
Lucky you.
Yes, and you.
The fact is that in the council's language, it is clear that it says it is exempted. If you look at the regulations and the example they give in the regulation, they say they are exempt from the tax. That's the zero rate, right? There's a tax there, but there's zero rate because they're QHTC. And then the income flows through to the partners. And that's the way it's supposed to be. So one of two things, we know that this entity is a qualified QHTC. The OAH court made that decision that notwithstanding the district's argument that they weren't because of a property tax issue that was separate and apart, was a separate one. The court said for this purpose, they are a QHTC. So if they're a QHTC and part of the issue on the QHTC is that you don't pay tax for the first 5 years on the income you use,
That's for corporations.
Well, no, if you look at it as well in the regulations, they say that as well. So what happens is that you've got these attributes. That income is QHTC income. And because of the aggregate, the district pushes them into aggregate theory. If you go to the aggregate theory, then the benefits of the QHTC, which is including training credits, which are credits that you take against your income tax. You don't take them against sales tax. You don't take them against property tax. They're still giving them those training credits. All of that has to flow through to the partnerships, to the partners. So under the
But that's not what Inc. tried to take, is it? I thought it just tried to deduct the full amount of its distributive share. It reported its distributive share and then it subtracted the same amount.
The income that was earned in the District of Columbia by a.
Right, but did it also try to take some training credits somewhere? I didn't see that in the
It
record.
has to, because again, under the.
But did it? Is it in the record? I mean, can you point me to a page of the record?
I can't point it to you right now, Your Honor, and I will be more than happy to supplement to the court on that position. But the issue, all of this is the district wants its cake and eat it too. It wants to say that we are an entity level, we're an entity theory for one thing, and then now you're going to be an aggregate. If you're an aggregate, you must take all attributes, which includes the credit. So this is what is causing the confusion. I totally agree with you, Judge Deal. This was not the best drafted language. Absolutely. But the district has taken that language and went ahead and treated that pass-through entity as a QHTC. It has given it all the other benefits. It says you are a QHTC. It's just,
Well,
it's bad.
it is a QHTC. It's just not an unincorporated business.
Well, it is it is an
Well, I mean, it
it's a
is in
pass-through-
common parlance, but
it's a
but
pass-through
it's-
entity.
the
And-
statute says it's not. So,
Well, it's a pass-through entity though, Your Honor. And under the aggregate theory of partnerships, that income, along with all the warts, all the positives, all the negatives, if there were NOLs, if there were other credits, if there anything else, that passes in its entirety down through the partnership and is distributed out.
I have one other question I want to ask you, but would you tell me in a 28K letter where in the record it shows that Inc. tried to take a credit for the retraining costs? I just didn't see it. I probably just wasn't
Yeah,
reading.
it's
the
probably
fine.
on the return, Your Honor, and that means I have to shred a return. But I will do so.
I mean, if it's in the record, just point it out
Yeah,
to
I
me.
mean-
But here's my question for you. I thought, and let me just explain that. I know that there was a time at OAH when this case was consolidated with the Accenture case. And so I may be mixing up cases. And if I am, I apologize and you can correct me. But there was at some point you argued that OTR had taken inconsistent positions on this. And that sent me to looking at the regulation that OTR promulgated to implement the statute that included this language about QHTCs not being unincorporated businesses. So there was a notice of proposed rulemaking where OTR said, here's the rule we're putting out there, and it includes this example about how an individual who's a partner in a QHTC, I guess, would report the distributive share of income on their tax form. So that went out as a proposed rule. And then, according to the notice of final rulemaking, there was a council member who commented on the proposed rule, not on this particular point, but commented on some other aspect of the proposed rule and said, you know, you got something wrong, or we meant this instead of that, or something. I forget what it was, but didn't comment on this particular issue. But the point I'm getting to is that if the council added this language in haste and did something it didn't really mean to do, there was that opportunity in commenting on the regs to say to OTR, no, this is wrong, this is not how we meant it, and yet nobody did. And so to me, that weighs against deviating from what I think is clear statutory language because they didn't quite draft this in the wisest way. What's your response to that? That's my question, and I apologize for the long wind up to get to it.
No problem, Your Honor. I have a long wind-up response. I think the biggest issue is, one, I do not know. I'm going to be glaringly honest with you. I do not know. I was probably not in the district when this was back in 2000. I had just moved back from the West Coast and just was not representing Bloomberg. So I do not know the reason why not only it, but all the other entities that you see in the record that Councilman Evans brought to the table. And they discussed at length that whole issue about the QHTCs and the pass-through entities, all of that. I mean, obviously some comments were made. They were taken, you know, I don't know if they were taken into consideration or not. And I do not know if during the reg period, the comments were made. I just do not know, Your Honor. I mean, I will try to do as much research as I can, or more importantly, I will get one of my associates to do the research. Can, and see if, you know, dig deep and see if we can find anything, you know, that would support that, and be more than happy, you know, if I don't find anything, I'll report that back to the court. If I find something, I'll share that with the court and obviously counsel as well. Thank you, Your Honor.
Thank you, counsel. We'll give you a few minutes for rebuttal. We'll hear from counsel for the District of Columbia.
Good morning, honors. May it please the court. Chris Mendez on behalf of OTR. The relevant statutes here are clear. They do not provide the credits that Bloomberg seeks for tax years 2015 to 2017. In fact, Bloomberg hasn't pointed to any statutory provision that provides the credits that it seeks. That right there is fatal to its argument because, as this court has noted in Ezekiel, tax exemptions are not implied in statutory text. Here you have 180801 subsection 5, which exempts unincorporated QHTCs from the franchise tax. The way that it does that is by defining unincorporated QHTCs out of the definition of an unincorporated business. It is undisputed that during the relevant tax years, Bloomberg Incorporated was not an unincorporated QHTC. So therefore, that exemption from 180801 subsection 5 does not apply to it. It only applies to the BLP.
Did Bloomberg Incorporated have other DC income that it was taxed on? I mean, LP is not its only interest in the district, is that right?
I'm not sure if there was other income, but ultimately that's not dispositive to the issues here because ultimately this is a question of whether the pass-through income that originated from BLP is subject to the franchise tax at the ownership level, Your Honor. And then, of course, so 180801 subsection 5 does not exempt Bloomberg from the franchise tax at the ownership level. Under 180302, I believe it's subsection 5, that statutory provision requires Bloomberg to include the flow-through income that originated from BLP on the computation of this income for purposes of taxation in the district. There are, of course, a variety of different exclusions and exemptions under 180302 to various categories of income. But when you look at the statutory text, there is none whatsoever that comes even close to applying to income from an entity that was exempt from the franchise tax on unincorporated businesses. There is, of course, subsection A2D of 180302, but that cannot be the basis for the credits that Bloomberg seeks. The reason why that can't be the basis for those credits is because subsection A2D only applies to income that originated from unincorporated businesses that was subject to the franchise tax. Here, the income from BLP, or here rather, BLP is not an unincorporated business, nor at the entity level was it subject to the franchise tax. So that subsection cannot be the basis for these credits. And I do want to address another point that my friend on the other side has made. That's this notion that somehow an exemption from the franchise tax is the same as a 0% tax. That is not the case. BLP was wholly excluded from that unincorporated business category. It's not as if there was a 0% tax assessed against it. That's incorrect. Nor does the 6% rate
Can I just interrupt and ask why you care? What's the import of that?
My
I
understanding.
mean, whether or not, I mean, I hear them saying, I kind of understand the argument, though I find it a little semantically confusing that you are taxed even when at 0%. And I hear you saying, well, they weren't even taxed at 0%, they were exempt. These sound like ethereal, totally differences that it's 6 on one hand, half a dozen on the other. It's a semantic point. Who cares? Well, what relevance do you attach to it? I mean, you're now making the point too, so I'm just curious why we're talking about that.
I do agree. Ultimately, that's a semantic issue that doesn't matter. I just wanted to push back on that notion because as I understand, I don't want to speak for my friend on the other side, but at least as I understand the argument is that there is a 0% tax at the entity level. So therefore, the franchise tax that's being assessed on Bloomberg is a form of double taxation. That is incorrect. That's just a semantic difference that has no basis in the law. But in any event, even this court were to come to the conclusion that somehow that is relevant. I mean, it is just absolutely false, given that this is an exemption, not a 0% rate. Had there been a 0% rate applied, the statutory text would look a lot different when you look at 1808 subsection 5.
Understood.
Your opponent said something to the effect of Bloomberg Inc. was able to take the QHTC training credits at its level. Is that right, your understanding as well?
I'm
I
not
may
sure.
have misstated what she said, and I'm sure.
I'm not sure I've seen that in the record. I really don't have a view on that point, one way or the other. But in any event, what they're challenging isn't a question of training credits. It is the application of the franchise tax.
I
to
mean, I
Bloomberg.
guess if what she said or what I thought she said is true, it seems to be suggesting that for some purposes, Bloomberg Inc. gets to take some benefit of LPs being a QHTC, while for other purposes, it's being denied the opportunity to take a credit for that. That's my reason for interest in the question. I'm not sure it leads to that result, but.
Again, I'm not sure that I saw that in the record, at least as where I stand right now. But I think one of the problems with that argument that opposing counsel seem to make is the fact that it never made that argument, as far as I'm aware, certainly not in the briefing before this court. And I don't think he even made that argument, as far as I'm aware, in the lower court proceedings, with respect to any relevance that these training credits may or may not have. So as a factual matter, I'm not sure that my friend on the other side is correct. But in any event, that issue is not before this court. They could have made that argument. As far as I'm aware, they didn't. They certainly didn't before this court, Your Honor. Now, I wanted to push back on another point, and this leads me to a separate but related problem with Bloomberg's arguments. That's this notion that there is any form of double taxation. Of course, generally speaking, there are at least two potential types of double taxation. There's one when you have double taxation across multiple jurisdictions. Another is one jurisdiction taxing income twice. What I understand Bloomberg's argument to be is the latter, that somehow the district taxed this income twice. And Bloomberg is patently incorrect that there is any double taxation by the district here. I think it's fair to say that it's undisputed that BLP, as a unincorporated QHTC, was exempt from the franchise tax during the relevant tax year. So therefore, at that entity level, there's no taxation whatsoever. It is exempt from the franchise tax. That income, that flow-through income that originated with BLP, it was only taxed at the ownership level. So Bloomberg's assertion that double taxation occurred here by the district just ignores the undisputed reality that only Bloomberg was taxed on the income, not BLP. And my friend on the other side made some points with respect to legislative history. I do want to spend a little bit of time on that. With respect to legislative history, I don't think it's ultimately necessary for this court to rely on the legislative history to affirm OAH's final order. The reason why is, as I led with, the statutory text is clear. It only leads in one direction, and that's in OTR's position. That should only lead to affirmance of OAH's final order. But in any event, if this court were to consider that legislative history, it only supports OTR's argument. What is critical here is to look at what is the purpose of this particular exemption, because that's what this case is ultimately about. That exemption that appears in 1808-01 subsection 5. Now, with respect to that exemption, in the QHTC bill, it is section 405 of the QHTC bill. And when you look at the committee report, the legislative history is clear. The purpose of that particular exemption was to eliminate the possibility of double taxation in multiple jurisdictions based on income from unincorporated QHTCs. To be a little bit more specific with that, the specific concern with respect to this exemption was that non-resident individual investors, so investors who were not residing in the district, that at that time, there was the possibility that their the income they might have received from investments could be subject to double taxation, because prior to that, they're not DC filers, so they would not be able to benefit from the A2D exemption. So prior to the QHTC statute being enacted, that income at the entity level would have been subject to the franchise tax. And then at the ownership level, it ultimately would have been a question of whatever state or jurisdiction they did file in and how that state or jurisdiction treats that flow-through income. So there's that possibility of double taxation for those individuals. When you look at the legislative history, it had nothing to do whatsoever with this notion that somehow there's this intent to exempt corporate companies, corporate owners from the tax on flow-through income from unincorporated QHTCs. It just doesn't appear anywhere with respect to the discussion regarding section 405 that became this exemption provision, or even more broadly, when you look at the committee report.
I know the committee report is in the record. Do you have a page citation to either the record or the committee report itself for the notion that the double taxation that was to be avoided was double taxation in multiple jurisdictions?
Yeah, I do, Your Honor. So I would point you to the testimony of Timothy Hart. If you look at the committee report, not all of it is internally paginated, so it is on page 54 of the PDF. Testimony of Timothy Hart, as well as the testimony of Sanford Saunders at page 109 of the PDF. And what they discussed, particularly Mr. Saunders, is his witness statement that he submitted. What he discusses was this concern about how there's the possibility of double non-taxation for individual investors who are not residents of the district.
On a more general level, how do you make the leap from what witnesses told the council to what the council's intent was?
I'm not sure that's a leap at all, because it seemed to be just when you look at these witness statements and testimony from various witnesses, it seems to be that the general consensus, and I see nothing that suggests otherwise, the general consensus seemed to be that this was this provision in particular was meant to deal with a narrow problem that existed at that time. There's no suggestion whatsoever that would suggest otherwise, at least what my friend on the other side is saying. So I don't see it a leap at all. In fact, I would also point you to the testimony of Jay Young. This would be on pages 125 to 126 of the committee report of the PDF. And even him, so he had criticized the provision as it was being considered and as it was enacted. He had criticized that provision by saying he couldn't support it as it was written because it didn't do exactly what Bloomberg is asking for, which is exempt corporate owners from the franchise tax on flow-through income that originated from QHTCs. So whether we're looking at the witness statements that were in support of this exemption provision and what OTR, is OTR's position with respect to what it means, or you even look at the opponents of this provision, there seemed to be a general consensus. And that general consensus was that it doesn't do what Bloomberg suggests that it does, or rather it wasn't meant to do what Bloomberg suggests that it was meant to do. So in sum, neither the legislative history nor the statutory text, so neither the legislative history nor the statutory text supports the notion that Bloomberg is somehow entitled to the credits that it seeks. What seemingly Bloomberg is asking this court to do is to insert statutory language, or is to assert rather an exemption that simply is not in the statute. And there is no basis for that whatsoever. If there are no further questions, Your Honors, OTR respectfully requests that this court affirm OAH's final order. Thank you, Your Honors.
Thank you, counsel.
I do have one question for
Sure.
you. Has OTR changed its position on this at all? Your opponent makes something of the fact that the forms used changed, OTR's guidance about what form LP should use to report changed, and I think is implying some change in its interpretation of the statute. What's your answer to that? Was there a change in OTR's interpretation?
That's not my understanding, Your Honor. So prior, if I understand opposing counsel's argument, was it had to do with the precise form that was submitted prior to 2014. Unincorporated QHTCs had to file the D30 form. But what's important to note with respect to that is that even in at least the forms I've seen, it was pretty clear that unincorporated QHTCs were still exempt. So there wasn't a substantive change in position in terms of what the law did. It was just a matter of which form needed to be submitted. Since 2014, the guidance has been for these entities, unincorporated QHTCs, to submit only the D65 form. Again, I'll acknowledge there has been a change with respect to the guidance regarding what forms to submit. But in terms of the substantive tax treatment of unincorporated QHTCs, that hasn't changed. But in any event, it is undisputed that during the relevant tax years, this is ultimately about the 2015 to 2017 tax filing years, there's been no change whatsoever, whether it's the substantive tax treatment or the guidance with respect to which form to submit.
Thank you.
Thank you, Your Honors.
Thank you, counsel. We'll give you a few minutes for rebuttal.
Just a couple of things, Your Honor, that I found just probably an answer to one of your questions. I went and pulled the Qualified High Technology Company tax benefits. That is a publication of the district. It is in the appendix. And it notes that the corporate QHT, that the tax that the QHT applies to on the corporate level is a franchise tax, not an income tax. So it is an equal tax in that it is a franchise tax with the unincorporated businesses. One of the things other things that you find in this particular, the guidance that was provided also for tax benefits for unincorporated QHTCs. One of them is a deduction for Internal Revenue Code Section 179 expenses up to $40,000. If they can't file that, they can't file a UB return. They can't take that on the UB return. They have to take that on, that attribute flows down to the partnership, to the partners, and is flowed and is distributed however they about their, to the extent of their ownership interest in that. So that also is pushed down, which is another indicator that those attributes, including the benefit for the tax, if they want to argue that this is you all of a sudden have switched to an aggregate theory, these companies never cease to be QHTCs, never. And the benefits that they have never stop. So it is disingenuous to say, okay, we're going to parse out this but we're going to do this.
Where in the record is this piece of
It
paper?
is in, I have to give you I will forward it to the court. It is the QHTC information, the benefits that the District of Columbia published. I will make sure that the court gets a copy of this and the thing
I
from.
mean, is it in the record?
It's in the record, Your Honor. One of the other things is my learned opponent here, or my learned colleague here says that, that corporate owners don't get this pass-through type thing. Well, of course they don't. Corporation, the tax and the benefits stop at the corporate level. The only way the owners of the corporation get any benefit to this is in their dividend. Should the corporation issue a dividend, then those dividends are taxed by the recipient in their particular state. So that's the whole issue of this whole entity, this pass-through entity boondoggle that the district has gotten itself into. Pass-through entities aren't corporate, but they're subject to the same tax. It's a franchise tax. They can put a label on it, call it corporate franchise tax or UB franchise tax, but the basis of it is the same. They are franchise taxes. Based on my previous argument and the submissions that we have done, we ask the court that it please overturn.
Let me ask you just one
Yes,
question.
sir.
Kind of no pun intended here, but just one kind of last shot at it because you've answered it a couple different ways already, or through a couple different questions. Why shouldn't we just let the council clean up its act? Why should we be doing that?
Because the statute is ambiguous, and this court has, our position is that statute is ambiguous because it doesn't address the QHTC. The district has, if you look at it, the district is saying, yes, you're QHTC. It has never backed off from that position. And then the other hand, it says, oh, but unincorporated businesses can't be QHT, and it's waffling back and forth. It is important that the court has the ability to look through and see that there's an ambiguity and to say, okay, all of the things surrounding this topic, what are the things that indicate that the taxpayer's position is a reasonable position to take? And you have that ability. It is our belief you have that ability. And as much as I love the DC Council, and like I said, I moved here in 2001. So I've gone through I pay close attention to all the tax bills that are pushed out by the DC Council and their tax positions. And there are times, as in every state, because the council serves as the legislature for the District of Columbia. And I look at Virginia because I work in Virginia and I work in Maryland, and I see the legislatures don't get it right all the time. But that's what the courts are for. The courts are to sit there and say, this isn't matching up. what you say in one section of this, of the code, where you say you're a QHTC and these are all the things that you have, and then you go to another section of the code and there are two opposing beliefs or two opposing indicators there, that's when the court can step in and say, let's look at the legislative intent. What was the legislative intent? It was to grant tax relief or no tax on the income derived by a QHTC within the District of Columbia on its business activities. And so we ask again that the court please overturn the ruling of the OAH, find in favor of the taxpayer. And we'll be more than happy if the court asks for any supplemental briefings or anything, we'd be more than happy to do that. We thank the court for your time and your patience.
Thank you, counsel. The case will be submitted and the court stands adjourned.
Oh.